Good afternoon and welcome to this afternoon's webinar, which is our annual update on public procurement law. My name is Chris Tayton and this is my colleague Emma Berkshire. And for those of you who don't know us, we're both lawyers who specialise in public procurement law. We advise public bodies on how to run compliant tenders and bidders on what to do if they feel that their bid has been unfairly marked. Usually in our recent update webinars, we've started by looking at the law and then ended up with a quick section on Brexit. But this year, Brexit is such a dominant feature and is so imminent that we're going to start by looking at what's likely to happen in the coming months.
So just before we start off on that, a quick reminder of the relevant legislation that we're going to be talking about today. Mainly we're going to be focusing on the Public Contracts Regulations 2015. This is the piece of legislation which applies to most of the tenders that you will be participating in or running. They apply in England, Wales and Northern Ireland. Some tenders will be governed by some of the other associated pieces of legislation which we have listed on the slides there. There may be some slight differences if you're dealing with one of those pieces of legislation, but most of the same principles will apply. And the sorts of tenders, again, that we will be talking about are those that are run by public bodies, are above the financial thresholds, which are set out on the slide there. And there are some exceptions to that, where certain types of contracts may be governed by the light touch regime, or maybe below the financial thresholds, in which case some basic requirements will still apply, but not the full regime.
Brexit is rarely away from the headlines. In the last 7 days alone, we've seen the WTO's announcement that terms have been agreed for Britain to remain a party to the Government Procurement Agreement, known as the GPA. We've seen the government pay out £33 million to Eurotunnel for a Brexit-related public tender, or more accurately, a non-public tender. We've seen Parliament voting on what will happen if Parliament rejects Theresa May's deal later this month. If that happens, we now know there will be further votes on delaying Brexit and on ruling out a no-deal Brexit. And Labour's full position has changed, and they now support holding a second referendum on the UK's membership of the EU, so potentially the whole of Brexit could be reversed. The big question for today's webinar is how Brexit will affect public procurement in the UK. And we start by looking at the legislation covering the possible Brexit outcomes. First up, we have the European Union Withdrawal Act 2018. This is the legislation which will take us out of the EU, absent a withdrawal agreement with the EU or a reversal of Brexit. And it will achieve this by repealing the European Communities Act, which took us into the EU in 1972. The most important aspect of this Act for public procurement is Section 2.1, which provides that all domestic UK legislation that was made under the 1972 Act continues to apply. And this includes all the procurement legislation Emma mentioned at the outset. Also, any case law of the European Court of Justice prior to exit day continues to apply. However, it will no longer bind the UK's highest court, the Supreme Court. The Withdrawal Act also gives the government power to make additional secondary legislation to update UK domestic law. This is to ensure that it is consistent with the UK's exit from the EU. The short answer, therefore, is that very little of legal substance will change to the procurement rules on exit day. As just mentioned, where UK procurement legislation is inconsistent with the UK leaving the EU, the government has the power to amend it. And we now have two draft statutory instruments laid before Parliament which do this. First, we have the Public Procurement Amendment EU Exit Regulations No. 1, which was laid before Parliament on the 13th of December last year. This amends the Public Contracts Regulations, the Utilities Contracts Regulations, and the Concession Contracts Regulations. The most significant change is to stop businesses based outside the UK from bidding for UK public contracts. This does not stop businesses based in the UK owned by overseas companies from bidding, just businesses based outside the UK. And this is to mirror the position that the remaining EU member states will take towards the UK. UK will no longer be a member of the EU, so the legislation of the remaining EU member states will prevent UK-based businesses from bidding for that work. As we'll see, excluded from this prohibition are public contracts covered by the WTO's General Procurement Agreement. So what are the other main changes that this statutory instrument will bring about? Firstly, OJ and Tenders Electronic Direct, or TED, will cease to apply to UK public contracts. Contract notices and contract awards and other notices for UK public contracts will no longer be published in OJ. Instead, the UK is setting up a new UK e-notification service, which will form broadly the same service. Those public bodies who use e-senders to submit notices to EU publications will need to check they have completed integration work to continue working post 29th of March, and those who don't and publish directly need to register with the new UK e-notification service. Contract Finder will continue to apply alongside the new UK e-notification service. So businesses who bid for UK public contracts will now need to check the UK e-notification service for future contract opportunities instead of OJ. Also, the standard form notices required for advertising in OJ, and which you will all be familiar with, will be revoked. The new UK e-notification, we're told, will instead obtain the relevant information when you input and upload your contract notices. Finally, the power to set the thresholds for the different types of public contracts, being public works contracts, public supply contracts and public service contracts, will move from the European Commission to the Minister for the Cabinet Office. EU-based businesses will not be excluded from bidding for UK public contracts where the Government Procurement Agreement applies, and vice versa. One of the big stories of the last week has been the announcement by the World Trade Organization that terms have been agreed for the UK to become a party to the Government Procurement Agreement in its own name. This has been a long rumbling issue ever since the referendum. The UK holds dual membership of the World Trade Organization itself, hence all the recent discussions about trading on WTO terms in the event of a no-deal Brexit. However, government procurement is expressly excluded from WTO terms. Instead, some members of the World Trade Organization have entered a separate agreement, known as the Government Procurement Agreement, which opens up their respective public procurement markets to each other. The Government Procurement Agreement was entered whilst the UK was a member of the EU. This means that the UK was not a party to this agreement in its own name, just as a member of the EU. So this week's announcement was that the UK could be admitted as a party to the Government Procurement Agreement in its own name, and on identical terms to those that have been agreed by the EU. Because the UK cannot enter any trade deals in its own name whilst still a member of the EU, this cannot be entered straight away. There will be a 30-day period for it to pass through Parliament, so potentially it could be enforced by the end of April this year. The big question is whether it will fill the gaps in public procurement caused by Brexit. The short answer is that it will fill some, but not all of the gap. The Government Procurement Agreement requires each of the parties to agree a set of schedules which confirm the type of goods, services and public works contracts it will open up to this procurement market, and the thresholds that will apply. It also applies a principle of reciprocity. Each party only opens up its markets to the extent that other parties open up their markets to it. As the UK's schedules will be identical to the EU's, they, in theory, will be opening up their respective procurement markets to the maximum. However, it will not be the same as the current EU procurement regime. Firstly, the list of services and goods covered by the Government Procurement Agreement is more limited. For example, under the current EU regulations, all services, subject to specific exceptions, are included. Procurement under the Government Procurement Agreement is restricted to a limited number of services. Also, the GPA does not create a tariff-free public procurement market. Although UK-based bidders will still be able to bid for certain EU public contracts, they will need to factor into their prices any tariffs that will now be payable, principally on goods, to exports to the EU. And also, need to remember that the GPA is not restricted to the UK and EU. Other major economies are parties to the GPA, including the USA and China. A full list can be found on the WTA website. And UK domestic law will be updated to reflect this through two statutory instruments, both the Public Procurement Amendment EU Exit Regulations numbers 1 and 2, the last of which was laid before Parliament on the 12th of February this year. These provide that for a period of 18 months after Brexit, the UK's procurement regulations will allow GPA states to bid for UK public contracts on the terms of these regulations. So that covers the legislation that has already been enacted or is currently before Parliament to deal with Brexit. But politically, things could change radically between now and the 29th of March, meaning that some or all of what I've just been talking about would not apply. The twists and turns of the Brexit debate through Parliament have been complicated, and no one knows for sure how this will turn out. There are broadly two other options relevant to public procurement which might happen. First, we have Theresa May's Withdrawal Agreement. This has been rejected by Parliament, has been heavily criticised, but is still alive and remains on the table. The political issues of that agreement go far beyond the scope of today's talk. We will just look at what will happen to public procurement if the agreement is approved broadly in its current form. Firstly, from exit day there will be an implementation period running from 1 p.m. to 11 p.m. on the 29th of March until 31st of December 2020. During this period, the world of public procurement will be virtually unchanged from the position we have today. OJ will still apply, and the European Court of Justice will remain the final arbiter of disputes. The section of the draft withdrawal agreement dealing with public procurement is Title 8, Ongoing Public Procurement, which confirms what I've just said. The one change is that it clarifies that the EU procurement directives will not just apply to tenders which have concluded during the implementation period. It will also cover ongoing tenders and contracts to be awarded under the framework agreements as at the 31st December 2020. Under the no-deal scenario, the EU procurement directives would cease to apply straight away. And the other political outcome, depending on which way the vote on Theresa May's deal goes, is a possibility of delayed Brexit or no Brexit at all if we have a second referendum. That is the simplest situation to explain. If Brexit is delayed or does not happen, nothing will change for now. Another interesting question is what impact a no-deal Brexit would have on public procurement in the UK. The UK and EU procurement markets are substantial. 2015 figures report the UK's market was worth 265 billion and the total EU market was worth 1.5 trillion. Since Brexit, or since the referendum, the European Commission has published a 179-page statistical report which analyses in very great detail the extent of cross-border public procurement and shows some interesting results. Of the above-threshold public contracts awarded by UK public bodies, only 2.5% go to businesses outside the UK. And of these contracts, 50% go to businesses based in the EU and 50% to businesses outside the EU, presumably under the Government Procurement Agreement. In percentage terms, this is quite small, although we do need to remember that we're still talking about billions of pounds worth of contracts. Looking at the UK's performance when bidding for public contracts from other EU member states, there is a similar position. The UK wins about 2% of the above-threshold public contracts awarded by other EU member states. Again, this is a small in percentage terms, but still billions of pounds of contracts. When assessed in percentage terms, and bearing in mind the continued access to EU public contracts through the Government Procurement Agreement, one view might be that the public procurement market will not be unduly affected by Brexit. This thought is, of course, of little consolation for businesses for whom EU public contracts are an important market. Brexit may still have a devastating effect on them. Also, what this analysis omits is the wider impact on the public procurement market that a no-deal Brexit might cause. We still do not know what the economic impact of a no-deal Brexit will be. But if we lose tariff-free trading with the EU, and if this causes an increase in the prices paid by the UK businesses for materials and goods, those increased prices are going to filter through into tender prices. In that scenario, procurement would be affected. Today, we don't know the answer to many of these questions. One way or another, they're going to have to be answered over the next few weeks. Next, we're going to look at possible future reform to procurement in the UK.
So if a no-deal Brexit does happen and we become subject to the GPA rules, what might that mean for the future of public procurement? Well, we know from the draft amendment regulations that there's no immediate changes planned, but it might be on the government's agenda to reform at some point. What's that going to look like? In terms of remedies, the GPA framework is not too dissimilar to our existing regime, but it's not as extensive. The basic requirements that must be met are, firstly, that we must have an independent review procedure, but it's not too prescriptive about what that might look like, and each jurisdiction is permitted to create its own rules. Secondly, there must be a minimum 10-day limitation period. Well, that's even shorter than the already short 30 days that we have at the moment. There are no requirements to hold standstill periods or have an automatic suspension of the contract if the review procedure is invoked. And finally, the remedies should include corrective action or compensation, but the latter can be limited to the costs of tendering and or the costs of bringing the challenge. So we wouldn't necessarily be able to have lucrative damages claims for loss of profits under a GPA regime. One possibility that is being talked about is the idea of establishing a specialist procurement appeals tribunal. At the moment, most procurement cases are heard in the Specialist Technology and Construction Court, which is a division of the High Court, but this is really more by accident than design. Many cases have nothing to do whatsoever with technology or construction. In other areas of the law, such as employment, property, immigration and tax, we have specialist tribunals which hear cases in the first instance. The advantages of a procurement appeals tribunal would be that it can set its own procedural rules. It would usually have much faster timescales and be much cheaper than traditional High Court litigation, and it could also have specialist judges who deal exclusively with procurement cases. The disadvantages might be that tribunals can sometimes be seen as less robust than the High Court, and this could lead to more appeals, ultimately prolonging the process. Most tribunals at the moment also do not award legal costs, so that might be a concern. However, it's all really just speculation at the moment. As with everything, we will just have to wait and see what happens. So now we're going to move on to talk about some of the recent developments in public procurement law over the last year. And the first case that we're going to talk about is Faraday and West Berkshire, which concerns development agreements. And the question is whether they constitute public works contracts for the purpose of the regulations. The land transactions do not fall within the regulations. That would be things like straightforward sales of land or leasing of land. But development agreements are often much more complex than that. They might involve the sale or lease of land, but there will usually be a lot of other provisions as well, as to things like what's going to be built, how it's going to be built, perhaps to the local authorities' specification. There might be terms as to the provision of public services or community buildings as condition of the development. In the Faraday case, West Berkshire had entered into a development agreement following a basic procurement process, but it wasn't a full regulated process. And the Court of Appeal decided that this agreement was unlawful because although it did not oblige the developer to carry out any works and was not therefore initially a public works contract at the point it was entered into, it did involve an option for them to purchase land, and after they had exercised that option, they would then be obliged to carry out development works, which would constitute public works. So the court said this means that the agreement would become a public works contract in the future when the option was exercised, and would therefore become unlawful at that stage. So the court made a declaration of ineffectiveness in relation to the contract, which was the first one ever made in the courts of England and Wales. Declarations of ineffectiveness lead to a fine being imposed on the public body. In fact, only a nominal fine was ordered in this case because the court recognised that there had been no deliberate intention to breach the regulations by Westparks, but it's potentially a very serious matter. It may still be possible post-Faraday to structure a development agreement in a way which does not fall within the scope of the regulations, but following this decision it would be quite a risky thing to do. So for public bodies you would be advised to follow a regulated procurement process in future before entering into any development agreements. Moving on to look at when a bidder can bring a challenge. There are three key circumstances. The first is where the public body has not complied with a provision of the regulations. And the key obligations on the public body are set out in Regulation 18, which are to treat bidders equally and without discrimination and to act in a transparent and proportionate manner. The second is where a public body makes a decision which is based on the wrong facts. And the third is where a public body has exceeded its discretion or made a manifest error of assessment. How does all of that apply in practice? Well, we're going to take you through some examples and some recent case law on these areas. The first sort of category of challenge that we often see in practice is challenges to the design of the tender. And these tend to be based on things like publishing errors, typos, confusing or ambiguous language, requirements that can't be met, insufficient information, or requirements which favour one bidder over another. And we have an interesting recent example of a challenge to tender design in the case of AbbVie and the NHS Commissioning Board. This was a contract for the supply of drugs to treat hepatitis C to the NHS. And the claimant, AbbVie, challenged the use of a dummy price mechanism. The contract was split up into a number of different parts, and where bidders were not submitting a bid for all parts of the contract, the dummy price mechanism essentially gave the bidder a dummy price for that part to enable the price component of the tender overall to be assessed. AbbVie said that this gave an unfair advantage to suppliers who were not bidding for all parts of the contract, couldn't supply all of the market, compared to those like them that could, and therefore it was a breach of the principle of equal treatment. The court said no, it wasn't a breach of the principle of equal treatment. It said that how to assess price is within the broad discretion of the public body, and it was still possible for AbbVie to gain the highest score if it had bid for all parts of the market. It just depended on what prices it was going to bid. So there was no challenge upheld in that case. There is always an issue with timing when bringing challenges to tender design. The limitation period for bringing a challenge is 30 days, and this can be extended to a maximum of 3 months, but only in very limited circumstances. Due to the length of time that most procurements take, it's often the case that the 30-day time period will expire before, if you're a bidder, you have even submitted your bid, let alone before you know whether you've won or not. So if you're a bidder, you can't generally wait and see and decide to challenge only if you haven't won. Both bidders and public bodies should use clarification questions wisely at the tender design stage. If a bidder raises an issue around something in the tender which is ambiguous and therefore a potential breach of the transparency principle, this can be resolved usually quite quickly by publishing a clarification. If there's a potential equality issue, as there was in AbbVie, it might need some more work to resolve. For example, you might need to, if you're the public body, think about amending the tender documents and then giving a corresponding extension of the deadline for bids. But many challenges of this nature can be dealt with without the need for litigation. Next up, challenges to evaluation. In our experience, this is the most common type of legal challenge. It might be based on a failure to apply the marking criteria correctly. It might be a case of breaching one or more of the procurement principles in the course of the evaluation, or it might be something like failing to take into account relevant information. The big case on evaluation that we had at the end of last year was Lancashire Care NHS Foundation Trust and Lancashire County Council. This concerned a tender for the provision of nursing services, and the contract was awarded to Virgin. The Lancashire NHS Trust was the only other bidder, and they challenged the decision on the basis of what they said were a number of shortcomings in the evaluation and moderation process. The court found that there were inconsistencies in the way that the award criteria had been applied by the evaluators. Like many tenders, the criteria had a set of bullet points which set out the requirements of the authority in relation to each question, and the bids were scored based on how well they met those requirements. But the evaluators had taken different approaches to their marking. Some had gone through each of the bullet points individually, some had taken a more broad brush approach. The evaluators then held a moderation meeting to try and reach consensus scores. But the court found that the notes of these meetings were inadequate because they didn't provide a full or accurate account of the panel's reasons. And there was specific criticism of the template sheet which they had used for recording the reasons for their decision. It had two boxes, one for positive comments and one for negative comments, and they had listed under each of these boxes the reason for their decision. But there was no accompanying explanation as to how the positive and negative comments were quantified into a score, or how they correlated to the score given. It was obvious that some had been given more weight than others, but it wasn't clear which ones. And finally, the council was also criticised in the case for redacting the dates of the notes and backdating them when they were pressed for disclosure of the notes by the trust. What was interesting about the case is that the court didn't go through any remarking exercise to determine whether the trust should have won. It decided it didn't need to do so because it said that the council's failure to give sufficient reasons for the decision was in itself a material breach of the principle of transparency. And the scores awarded to the trust and Virgin were close enough that just a small increase in marks would have made a difference to the outcome. So because the council couldn't properly explain the scores, that was enough to set aside the decision. So this is a really important case for public bodies who need to learn some lessons about record keeping and clearly documenting the reasons for their decisions to avoid future challenges.
Another type of complaint we often see is that the successful bidder won because they submitted a ridiculously low or loss-making bid. Price can often be the decisive factor, particularly where 50% or more of marks are awarded for price. Abnormally low bids are regulated by Regulation 69 of the Procurement Regulations, and we've set out the key provisions on this slide. Regulation 69.1 is written in emphatic terms. Contracting authorities shall require tenderers to explain the price or cost proposed in the tender where tenders appear to be abnormally low in relation to work, supplies or services. On a plain English reading of this regulation, it appears to create an obligation on all public bodies to investigate bids which look abnormally low. Regulation 69 goes on to explain what can happen if an abnormally low bid is detected. There is then a duty on the public body to consult with the low bidder, and they can only reject the bid if the evidence supplied by the bidder does not satisfactorily account for the low level of price or costs. There is also an absolute obligation to reject the tender if the public body discovers that the low price has been achieved by breaking environmental, social or employment laws. For example, if they have an illegal workforce, or are paying below minimum wage levels, or if their solution breaks environmental law. This area of law was reviewed last summer in the case SRCL Limited versus National Health Service Commissioning Board. In this case, SCR's bid was approximately £479,000, and the successful tenderer's bid was £310,000. This was not the total value of the contract, it was the price bid for a basket of services under the contract. SRCL claimed that the winning tenderer's bid was abnormally low. They argued that Regulation 69.1 meant just what it said. In other words, that public bodies are obliged to investigate abnormally low bids. And in fairness to them, that is what Regulation 69(1) appears to say. Unfortunately for SRCL, the Court did not accept this literal interpretation of Regulation 69. Instead, they investigated the purpose behind the EU directive from which this regulation is derived. And they concluded that the duty to investigate abnormally low bids only arose where the public body was already considering rejecting that bid. And for that reason, SCRL's challenge failed. Nevertheless, a challenge on this basis is not dead. In cases where the price is so low that there is a realistic and substantial risk of non-performance, it may well be a manifest error for the contracting authority not to reject it. However, the test for proving that is very high. Merely failing to investigate a bid which looks abnormally low is not in itself grounds for challenge. Equally, if the unsuccessful tenderer has or is able to obtain evidence that the successful tenderer's abnormally low bid involves a breach of employment, social or environmental law, that would be grounds for challenge if the bid was not rejected. Next, we look at a series of cases we've seen over the last 12 months dealing with lifting the automatic suspension. You will all be familiar with the procedure that applies when a public body has completed its evaluation of the bids and has chosen the winning bidder or bidders. Regulation 86 obliges public bodies to send bidders a notice telling them the outcome, the reasons for the decision, and crucially, that a 10-day standstill period will now apply. Regulation 87 then provides that a public body must not enter the contract with the winning bidder until the standstill period has expired. If an unsuccessful bidder issues legal proceedings against the public body during the standstill period, that automatically suspends the contract award. If that happens, the public body either needs to await the conclusion of the legal proceedings before entering the contract. Alternatively, they have the right to make an application to court for an order lifting the automatic suspension so that they can proceed to enter the contract. Historically, it has been quite rare for public bodies not to be successful if they apply to lift the automatic stay. In the last year, there have been 5 cases where such an application was made, and in 2 of them, the bidder was successful in keeping the suspension in place. So we start by recapping on the test that the court applies. This is the long-established American sign bid test. First, the court looks at whether there is a serious issue to be tried. This requires bidders to prove they have an arguable case. It's not a high hurdle, and they do not have to prove that they will win a trial. In most cases, this part of the test is easily proven. Next, the court will assess whether the claimant can be adequately compensated in damages. If the court decides that the bidder's legal rights can be compensated by a money award rather than being awarded the contract, the court is likely to lift the suspension. And as part of this test, the court will consider whether it's fair to limit the bidder to the remedy of damages. The court will also look at the position from the public body's perspective. Can it be adequately compensated by a money award if the suspension is kept in place when it shouldn't have been? Where this test does not provide a decisive answer, the court will then look at where the balance of convenience lies. It will establish which outcome carries the least risk of injustice. And at this stage, the court will also consider the public interest in the contract being tendered. So let's quickly look at the recent cases where the court has been asked by a public body to lift the automatic suspension. In all of them, the unsuccessful bidder showed that there was an arguable claim. The court therefore looked at adequacy of damages and balance of convenience. The first case is Lancashire NHS Trust versus Lancashire County Council, which Emma mentioned earlier about evaluation. This was a £104 million contract for nursing services for children and young adults, and unusually, this was a procurement challenge between 2 public bodies. The court decided that the NHS Trust, the incumbent, could not be adequately compensated in damages if they lost the contract. This would involve them restructuring the delivery of healthcare in their region. It would also have a knock-on effect for other services and would lose them 160 employees. On the other hand, continuing the existing contract would have limited effect on Lancashire Council. The price differential between the winning and losing bids was small, and the council could be compensated in damages. The fact that a damage award would involve one public body paying compensation to another was also a relevant factor, as was the fact that the court timetable allowed for there to be a speedy trial shortly after the application, meaning that suspension would only have to be in place for a short period of time. Accordingly, the court refused to lift the suspension. Next is DHL Supply Chain versus the Secretary of State for Health and Social Care. This is another case involving the supply of health services, but this time by a commercial operator. In this case, both the public body and the bidder showed that they could not be adequately compensated in damages. DHL would lose a highly skilled workforce, which would hinder its ability to bid for other contracts, and the public body would also suffer loss that could not be adequately compensated. The court went on to consider the balance of convenience. Which outcome would cause the least risk of injustice? And the decisive factor was public interest. This was part of a wider health project which would be held up by the suspension of this contract. The public would benefit from the project starting immediately. Another influential feature here was that a speedy trial was not possible, unlike the Lancashire case. This meant the suspension would need to be in place for many months, and accordingly the court decided to lift the suspension. That brings us on to the Northern Irish case, Aircom UK Limited versus Department of Finance and BT plc. This was a high-value contract valued at between £50 million and £400 million for the installation of network services to run voice and video conferencing services for various public bodies in Northern Ireland. Aircom tried to argue that damages would not be an adequate remedy, as losing the bid would require it to close down its Northern Irish business. The court was unimpressed by this argument, as Aircom had provided little hard evidence to support this claim. The judge stated that courts should be cautious about accepting these arguments, stating that if such claims are made, they must be supported by convincing and cogent evidence, as it is a claim which is all too easily made. The court ordered that the suspension be lifted. Next, we have Bombardier Transportation UK Limited versus London Underground. This was a high-value tender for manufacture and supply of 94 new trains for the Piccadilly line in London. This was another case where the court found that damages would not be an adequate remedy for the bidder. This was due to the prestigious and high-profile nature of the contract and the damage to the bidder's reputation that losing the bid would cause. It was also decided that damages was not an adequate remedy for London Underground, so the court went on to look at the balance of convenience and noted the strong public interest in getting new trains. The existing rail stock was ageing and its reliability was reducing. And again, the court was influenced by the fact that a speedy trial was not possible, meaning that the suspension would be long-lasting. Accordingly, it ordered that the suspension be lifted. And finally, we have the case Central Surrey Health Limited versus NHS Surrey Down CGC, which is another case where the court refused to lift the automatic suspension. Unusually, this claim was made by a party who did not submit a bid, but was claiming that the tender should be rerun. They were a not-for-profit business, and as they had not submitted a costed bid, it was difficult to assess what their financial loss would be. It was also decided that NHS Surrey would suffer some losses, but on looking at the balance of convenience, this went in Central Surrey's favour. The court was again influenced by the fact that a trial would take place very quickly and that suspension would be in place for just a few months. So what lessons can be learned from these 5 cases? Firstly is that the court will, in the right case, keep the automatic suspension in place. It is certainly a factor for an unsuccessful bidder to consider carefully. But to have any chance of success, the unsuccessful bidder needs to show damages are not adequate. You need convincing evidence that you will suffer damage to reputation, or loss of workforce, or some other non-monetary loss. And for public bodies wanting to lift the suspension, you need to check carefully whether you can be adequately compensated in damages. And also look carefully at the impact of the suspension to the contract on the public. If the new contract does not materially change your existing arrangements, this probably won't be relevant. But if the suspension will delay a public benefit, this will not be in the public interest, and this can be decisive. And finally, and this is more difficult to predict, the court's timetable and whether you can have a speedy or quick trial seem to be very influential factors. And it's certainly worth unsuccessful bidders considering at an early stage whether to apply for a speedy trial, as this might improve prospects of keeping the suspension in place.
So an issue that crops up very regularly is disclosure. If you're a bidder, you want to get as much information as possible from the public body in order to help you determine whether you have a good challenge or not. If you're the public body, you need to straddle that fine line between not giving the bidder enough information or giving away too much, which might then encourage a challenge which wouldn't otherwise be brought. What information is the bidder actually entitled to? Well, the Roche Diagnostics case says that public bodies ought to disclose the essential information and documentation relating to the evaluation process actually carried out, so that an informed view can be taken of its fairness and legality. This is also echoed by the Technology and Construction Court's guidance note on procurement challenges, which says that the parties should act reasonably and proportionately in providing each other with information. But that doesn't mean that a public body needs to give away absolutely everything. Sometimes bidders will go on a fishing expedition. One thing that bidders very often want to see is the winning bidder's bid, particularly if there's a challenge that's based on unequal treatment. And understandably, winning bidders tend to be very reluctant to allow their competitors to have sight of their confidential bid. So what should a public body do if they are faced with a request for the winning bid, or if you're a bidder, when will you be entitled to see that? Confidentiality is not in itself a bar to disclosure. If the winning bidder's bid is relevant, then it will at some point have to be disclosed. There are ways around it, in particular the use of confidentiality rings. This is a mechanism that can be set up so that a confidential bid is only disclosed to a particular set of individuals. That might be just the lawyers, so that the actual individuals from the challenging bidder do not get to see the confidential information, or it might include select individuals from the challenging bidder. We had 2 cases last year which concerned disclosure of confidential information. The first one, Bombardier, concerned disclosure of actually not the winning bid, but copies of court documents, in this instance to a non-party to the claim. Bombardier were bringing the challenge, and one of their competitors, who was not party to the claim, wanted to gain disclosure of copies of the court documents from the court, which are normally considered to be public documents. Bombardier objected to this and said that their court documents contained confidential information about their own bid. But the court dismissed their objection and held that the information that was being sought, the court documents, didn't in fact contain any real confidential information. And there's a general principle of open justice which says that non-parties should be entitled to see these documents. So that was disclosure of court documents rather than an entire bid. In the second case, Marston Holdings and the Ministry of Justice, the successful tenderers did actually have to disclose their entire bid, but into a confidentiality ring. The court decided that this was necessary and the winning bidder's bid was relevant in order to determine whether the public body had acted unlawfully in that case. But they decided that there should be a confidentiality ring in order to give the successful bidder sufficient protection. And in fact, 2 rings were set up. Certain information was disclosed into a ring which was for lawyers only, and other information was disclosed into a second ring, which was also available to a specified individual from the lawyer's client. So all bidders and public bodies should be aware of these cases and should understand that confidential information, including winning bids, can and sometimes must be disclosed, but that you should think about the practical ways in which the confidential information of the winning bidder can be protected. And finally, remedies. So if you've been through the whole process and the court decides that the public body has acted unlawfully, what are the potential outcomes? The remedies available depend on whether the contract has been awarded yet or not. If the automatic suspension was upheld and the contract has not been awarded, then the decision can be set aside by the court. Can the court actually order the public body to enter into a contract with the challenger if it finds that they should have won the contract had the public body acted lawfully? This isn't a remedy which is provided for in the regulations. The court did consider it in the case of MLS Overseas versus the Secretary of State for Defence last year. It said that although the regulations don't provide specifically for this remedy, the court does have a general equitable power to grant mandatory injunctions, that is, an injunction which forces a party to do something. However, it said it would only very rarely exercise that power in a procurement case. The reason for that is that it involves ordering the public body to spend public money, and the invitation to tender documents will almost always include a right for the public body to abandon the tender. They are never obliged to enter into a contract with the winning bidder at all. So it would be strange then if the court could order them to do so. If the contract has already been awarded because the court lifted the automatic suspension, then the remedy is confined to damages, and damages are also available in cases where the contract hasn't been awarded as well. Usually damages will be based on the loss of profits that the bidder would have made had they won the tender. The case in 2017 of EU Energy Solutions and the Nuclear Decommissioning Authority cast some doubt on the amount of damages that might be available and said that bidders will only be entitled to them if the breach that they complain of is sufficiently serious. So no damages would be available for minor or trivial breaches. However, last year we had a conflicting European case which said that there is no requirement in the European Remedies Directive that a breach must be sufficiently serious before damages will be available, and that to have such a requirement would go against the spirit of the legislation. So the position on that is currently unclear. Any recent cases which have involved the award of damages, there hasn't been any argument about whether the breach needs to be sufficiently serious. So that's something which will need to be determined. If the contract has already been awarded, then damages are usually the only remedy, but in certain cases there is also the possibility of the court ordering a declaration of ineffectiveness. This is only available for serious procedural breaches of the regulations, such as failure to advertise or failure to hold a standstill period. It's quite rare, and as I mentioned earlier, we've only just recently had our very first English case in which a declaration of ineffectiveness has been made. There's also one earlier Scottish case, but those are the only two in the last 10 years that the remedy has been available.
Well, that brings an end to today's webinar. Thank you all for attending. We hope you found it useful and interesting. And if anyone from a public body or from a tenderer has any questions about the issues raised, or feels the tender is being unfairly challenged, or a bid has been unfairly marked, then please do feel free to contact us on the email addresses set out on this slide. We also have a website which has some recent procurement news on and other procurement updates. Later in the year we'll be running our yearly procurement challenge website, which goes through the whole process in a bit more detail and provides tips on how to successfully bring challenges and how successfully to defend challenges. So thank you again and goodbye.